Law School. And his law review article on litigation funding, The Shadows of Litigation Finance, was published by the Vanderbilt Law Review. He has been recognized by Law Dragon as a global leader in litigation finance, and he regularly writes and speaks on funding. Before joining Certum, Will spent several years at another litigation funder, where he managed litigation investments from sourcing and diligence through funding and resolution. Before that, he litigated commercial, constitutional, and appellate matters at Cooper and Kirk in Washington, D.C. He also clerked for Justice Samuel Alito of the U.S. Supreme Court and Chief Judge William Pryor of the U.S. Court of Appeals for the 11th Circuit. And I'll stop there. But one interesting thing is that when speaking, he has a very creative mind. So I've always enjoyed his speech engagements and talking to him. So Will, you have the floor, and welcome.
Thank you, Jose Antonio, and thank you to your entire team, Juan Pablo, Maria Lucia, and Ian, who have done so much to put together really an amazing conference year over year. And it's just such a pleasure to be here. We have two great draws today. One is a very interesting topic with some great panelists who I'll introduce. And the second, for those of you in this room, is free drinks afterwards. And so we will keep on time to get to that after. So I'll introduce the panelists, and then we'll get into the conversation. So starting with Lisa Snow, who is the founder and CEO of Snowbridge Global Advisory, which empowers business leaders addressing business risks, including arbitration, claims, and litigation through their focused valuation and forensic accounting advisory. Lisa provides strategic advice to general counsel, chief compliance officers, chief risk officers, including strategic business planning and advisory services. And one thing that I found very notable about her biography is that she founded Big Careers Little Kids, which is a nonprofit organization dedicated to empowering women in navigating their profession. Next, we have Celeste Cohen, who is a New York licensed attorney whose non-traditional law school experience led her to the United Nations Conference on Trade and Development in Geneva, Organization of American States Division in Washington, D.C. In each of these roles, she supported projects that related to international investment agreements, trade development, and competitiveness. The experiences fostered in her a deep appreciation of the various tools, much like transactional risk insurance and international arbitration insurance, that ultimately aim to strengthen commercial relationships and foster much-needed investment in trade domestically and globally. And Celeste is working on some pretty cutting-edge insurance products, which we'll be talking about parallel to. Then we have Jeffrey Commission, person no doubt known to everyone in this room, who is a director based here in Washington, D.C. with Berkeley Capital. He assesses and underwrites legal risk as part of her investment team, focusing on investor, state, and international arbitration. He has 20 plus years of experience representing and funding claimants in investment treaty disputes and international commercial arbitrations across the entire alphabet suite of tribunals. He previously practiced at Freshfields and has co-authored at least 2 books, Procedural Issues in International Arbitration, Third-Party Funding. Next, we have on her home field advantage, Kristen Young, who is a partner right here at White Case, where she practices with the International Arbitration Group, focusing on international investment treaty and commercial arbitration. He has been recognized as a future leader in legal arbitration, as one of the 2020 emerging leaders in private practice, and as a key lawyer in international arbitration by Legal 100. He also has experience in arbitrations before all the major fora, as well as in ad hoc arbitration. Experience spans a wide range of industries, including electricity, mining, and minerals, construction, oil and gas, textile manufacturing. And last but not least is my friend Sam Taylor, who works at SRM, where he leads the company's corporate intelligence practice in Americas. He has over 13 years of industry experience leading professional services teams, supporting clients in complex crises, and conducting investigations. He specializes in the US and Latin America, but has worked on engagements across the world, including Europe, Asia. He previously spent 8 years in Kroll, where he led the North American research practice and led the bank. We have a really interesting group of folks that kind of span the entire value chain of what it takes to litigate, finance, insure, asset trades. So there's a lot of topics we want to cover. Let me kind of just say at the outset, what we'll do is we'll dive into a couple of topics specifically, then we'll zoom out, talk about the state of funding, and we'll take some questions. I'll be monitoring the chat, but let's try to make this as interactive as people. Microphone, which I'll do a better job of. Great. But if people have questions, let's just make this a conversation. And so please raise your hands as we go along. So the first topic that we'll talk about is the UNCITRAL Working Group 3, and in particular, thinking about and looking at how they are talking about regulating litigation funding. And we have with us a member of that working group, Jeffrey Commission. So Jeffrey, you've been involved with that for a number of years. So do you want to provide us with an update on what the working group has been doing, and maybe with a particular emphasis on its relevance to third-party funding?
Sure, happy to do that, and happy to be here. So I guess the starting point is, before we dig into what's going on with UNCITRAL Working Group 3, of which I'm sure folks have heard something or other over the past 4 to 5 years, is where are we now in terms of third-party funding outside of UNCITRAL Working Group 3? And I think that's the starting point. And we're now at a point where third-party funding, at least in the terms of international arbitration, is part of the fabric of international arbitration. It is in the mainstream. It wasn't when I started practicing on funded cases in 2010, but in 2023, it really is. I mean, it's reflected in the rules. The leading commercial arbitral institution has a rule that contemplates third-party funding and provides for disclosure to avoid conflicts of interest. And the leading institution that's responsible for administering investor-state disputes, ICSID, recently introduced a rule. You can get a copy for, I think, $20 in your book of the rules. Highly recommend a paper copy. But so those are just two examples, the two most recent. But it really has become quite prevalent, both for the impecunious and for the well-heeled, so to speak. So we have that. It's in the mainstream now. And that it has to be contrasted with what's been going on at UNCITRAL Working Group 3, because what you have there and what you've had for some time is a very different process in a couple of respects. First of all, it's been going on for some time. ICSID started, I guess, 5 years ago and now has amended rules in place. UNCITRAL started more than 5 years ago, and there's no end in sight in terms of rules on third-party funding, so to speak. They have a much broader agenda. Admittedly, the ambit is ISDS reform writ large. So third-party funding is one of the many procedural issues that they're looking at, but they've taken a different approach. So what they've done, and I've been involved as one of the experts in consulting with them, and then participating as a representative of the International Legal Finance Association, is they heard concerns from states, they put together some proposals, and then they approached funders for comments on their proposals. So I participated in one of those initial calls several years ago. The problem is they presented us, and they basically asked for some wordsmithing observations. So they have these draft provisions, and they wanted us to give them comments on them. And then we asked them, well, what are the assumptions? How did you arrive at these provisions? And then they said, well, we have these 3 things that states have told us, and it's all based on anecdotal information. Number one, that third-party funding is increasing the number of frivolous cases against states. That's number one. Number two, third-party funding is increasing the number of the number of investor-state cases writ large. So because of funding, there's more cases generally. And they added the nuance that not only are there more cases, but the damages claimed are higher, again, because of third-party funding. And then they say that there's an increase in the number of cases in which states have unpaid cost awards. So those are the 3 assumptions that they went in with. We tried to talk about those assumptions. They weren't interested. Katia was not interested in having a conversation or looking at data about those assumptions. They just wanted comments on the proposals they put together that were based on those assumptions. So that was the starting point. That was several years ago. They had three models that they were looking at. One was a prohibitive model, which would ban third-party funding entirely, which is different from what's going on at the other arbitral institutions, so to speak. They had a permissive model, which is more like what the ICC and ICSID have done. And then they had a restrictive model, which would be funding with some limitations. Several years on now, we are nowhere near a rule from UNCITRAL. I attended a couple of months ago the latest session as an observer. They spent more time talking about damages than they did about third-party funding, although third-party funding was on the agenda. So there will not be a rule on third-party funding emanating from UNCITRAL this year, nor will there be one next year, perhaps the year following. And if I were to guess as to what it will look like, it will probably end up being the rule that ICSID has introduced, Rule 53 plus. So there's probably going to be some more disclosure that UNCITRAL is going to work in based on concerns from states. But I think it's still going to be mainly a conflicts of interest rule, and it's going to follow the permissive model. And that's because a number of states have come out and rightly said that, you know, because of access to justice issues, third-party funding is indeed part of the mainstream, and the rules should reflect that. But it's not something that's going to that we're going to see in terms of a concrete rule anytime soon. So that is an update in terms of what's going on at Working Group 3.
Great, thanks. And yeah, there can be, sometimes it's a great endorsement, right? If you're actually explicitly stated in the rules, but it can also present some challenges, especially as you go through the diligence process and in the litigation, as there might be some concerns about disclosures. Maybe Lisa, if you can start by saying a few words about that, how do you anticipate some of these changes, particularly around disclosure, might impact how experts are able, like yourself, are able to do their work? And in particular, the engagement of experts at the outset of cases for those of us who are here and are lawyers and are looking to get our cases funded.
Sure. Well, if it's okay, I'll answer your timing question first, which is how do I think it will impact the hiring of experts, and in particular financial experts at the outset of cases. And what I've heard from funders is that they insist or expect there to have been an evaluation of what the financial damages may be before a claim is made and before they would invest in that claim. And so therefore, and that is to be done by the parties, not by the investor. And so I think there is a push, at least from what I've heard. Jeffrey and Will, you can tell me what you've heard differently. But so I think there is a push. And I think in general, you've heard this on panels earlier, and this is not a self-interested statement. I do think outcomes tend to be better when financial experts are brought on earlier. We can help counsel and parties evaluate their strategies and hone their document requests and exchanges effectively through doing that. So that's my thought with regard to timing. Will, do you have thoughts about that?
Yeah, no, I think that's right. I mean, I think if you're entering it into an NDA, you can do your best to kind of preserve the confidentiality. And for a lot of people, it's just a necessity. You know, you have to do the expert work, you have to do that diligence work, otherwise your case isn't gonna get funding. So sometimes it's just the cost of doing business. And I think, you know, the efforts of people like Jeffrey are to help lower those costs, hopefully. And Kristen, can you weigh in here as a practitioner in the field, someone who is sometimes potentially looking for funding and then litigating cases? You know, how do you anticipate this is going to impact how lawyers conduct their cases? And also, can you say a few words about clients, and are clients concerned about these questions? How do they think about some of the disclosure rules?
Disclosure rules. Well, first I start by welcoming you all here to Writing Case. It's great to have you all here this evening, and please do stay for the reception after the panel. So in terms of what I think we will anticipate seeing in the future is what we saw yesterday. So IA Reporter reported on a new order and for a security for costs in a case called IMC versus Kiggers Republic. And one of the grounds on which the security for cause was issued is that the claim is funded, in that case it's contingency, and that the funding arrangement did not include coverage for an adverse cost award. Hypothetically, if one were to be ordered, there was no coverage. And so that was one of the bases on which the tribunal said, we're going to issue a security for cost. Parties, you go back and you determine the modalities, but it's, I think, $1 million. So was that prompted by disclosure? Because certainly that was known to the parties. In that case, of course, another fact was that the claimant beneficiary was subject to bankruptcy proceedings. But I think it shows that we may have an uptick in these types of requests for security for costs. And then the question is, do the funders need to make sure that they have coverage for an adverse cost award? If they don't, then who bears the burden of the security for costs order? And how is that going to be balanced between the client, the law firm, and the funder? So I think that's something we'll probably see more of. The other obvious one is, of course, an uptick of arbitrator challenges. I think we've already seen an uptick in arbitrator challenges, but with disclosure, you have further transparency in relationships, and certainly looking at, does the arbitrator have a relationship with the funder? Does opposing counsel, the arbitrator's law firm? So the questions then arise from the disclosures that are made. Of course, with the disclosure being made, hopefully that would preempt challenges because of course known from the outset. But I'm not saying it could not lead to additional challenges. So those are the two things, top of mind, I think, looking at that. In terms of clients looking at third-party funding and disclosure, I mean, it depends which side, of course, you're representing. I think there was always on the respondent side a question of whether there was a funded claim. Sometimes you could determine that it was through some investigation that you might do, and sometimes you just didn't know because it wasn't publicly available. But I think there had always been some effort to determine whether or not there was a funded claim. On the flip side, it might actually be in the interest of the claimant investor to have the disclosure because, again, it avoids potential conflicts down the road. Let's say the conflict emerges post-award. They then have a challenge on annulment. And so having that all be out in the open from the outset could be, in fact, in the claimant's interest.
One quick follow-up for anyone who'd like to take it before we move on. There's an argument in the disclosure debate that actually can help litigants because it signals that your claim is very strong. So it's kind of the opposite of the frivolous litigation argument, right? That you're not going to get funding, especially for a treaty case, unless it's pretty darn strong. From your experiences, maybe talking to arbitrators or litigating some of these cases, is there any truth to that? Is there any sense that maybe actually it could be good for arbitrators to know, especially former lawyers or currently practicing lawyers who've been through the process and know what it takes to get funding in a case?
I don't know that it makes a decisive difference because I do think, and it goes back to what states have conveyed, right, to UNCITRAL that Jeffrey mentioned, that there's a sense that it might in fact be inflated because that's required to obtain funding. So I certainly, if you have a strong case, you have a strong case. And so do you have evidence that supports the quantum you're requesting or do you not, right? So ultimately it's going to come down to whether or not you have the evidence in support. I don't know that it really would sway the arbitrators one way or the other. Certainly in this IMC Caregivers Republic case, it did persuade them to order in part a request for security for costs.
I think the information can be helpful to arbitrators in the sense that arbitration funding is another form of investment in a project, right? And to the extent that the parties otherwise have symmetry in terms of having to disclose the values and their evaluations of those projects as part of the discovery in the arbitration, then I think bringing in the information and disclosure about the funding enables the arbitrators to have a more fulsome picture about what investment really means.
And I want to get Celeste and Sam involved in the conversation here. And I think this is a good transition point to talk about enforcement, because one of the issues that is raising questions and leading to some of these conversations around disclosure of funding is a perceived rise in large awards. And the question is then, are you able to actually go and enforce those awards? And so there's a couple of ways to think about trying to enforce the award, right? One is to actually go get the assets. And second one we'll start with is potentially exploring insurance as an option. So Celeste, you work at Gallagher, which connects potential insureds with some innovative insurance products for this space. Can you tell us a little bit about what those products are and how they might help litigants? And as part of that, is it something that folks
the ability to collect under the award and sort of the asset tracing that takes place. So those are the two arbitration related products. In addition to that, if we're talking about recognition and enforcement proceedings here in the US, the broader contingent legal risk insurance market also offers adverse judgment and judgment preservation insurance. Those products are a little bit different in terms of the duration of the policies and the costs. The challenges that someone in an arbitration context might find with those two products is that the underwriters in the US market aren't necessarily familiar with international arbitration litigation proceedings, and they don't necessarily understand the third-party funding aspect of it. So it's not something that's in all of their appetite. The market's really split there. But again, if you ever have an inquiry or a specific matter, I would advise you to approach a broker like Gallagher, so that we can discuss the options that are relevant to the particular proceedings.
Interesting. And yeah, I mean, it's been, first of all, nice poise as we work through the audio problem, but it seems like it's back. And I think it mirrors the rise of insurance that we're seeing in the US as well, certainly with judgment preservation insurance and contingent fee insurance and other new products that are coming out. So Sam, why don't you jump in here and also tell us what you're seeing on the enforcement front? And to the same question that we talked about with Celeste, what's kind of the recommendation about when you're engaging asset tracers? Is it before the suit? Is it during, after? And maybe tell us how you work with litigation funders who are trying to project what enforcement might look like, 3, 5, 7 years from now.
Thanks, Will. So I think the broad trend that we're seeing, as Jeff mentioned, is just increasing amount of players in the space. A lot more claims, a lot more actions, and more funders as well, which has followed. And that's also led to an increasing number of investigators. And that's particularly in the last 5 years. When I came into the field almost 14 years ago now, there were maybe 2 litigation funders, and many of the counsel that we would work with would treat them, I don't know if disdain is the right word, but certainly with suspicion. And that's certainly, been a sea change, I think, over the last period of time about, how acceptable it is. And it's something that it's a type of client that we work with in the investigations and intelligence space quite regularly now. And that's, I think, altered the dynamic in that investigators are increasingly brought into the process much earlier. Firstly, that's as part of a cost benefit analysis. So it's prior to funding a case or prior to funding an award, trying to understand whether it's worth funding at all. Are there assets to enforce against? Were the claimants to win the matter? Or assets to enforce against, depending on the jurisdiction, how liquid they are, how attachable they are, et cetera. And there's been also, I think, a knock-on effect that we've observed as investigators, which are that debtors are increasingly savvy as a result. These kind of absconders, as you might call them, they now know what are the jurisdictions that are easiest for them to move funds into in order to avoid attachment and enforcement, and how quickly they might need to be moved. And that forms a key part of the work that we do as investigators or asset tracers, what have you, which is we're brought in at the beginning, but we're also, I think, best utilized as a continuous monitoring process, because you want to observe what your counterparty is doing, where they are moving assets throughout. We can be brought in at the beginning as part of a snapshot in time, but if you stop there and you don't keep looking, the assets could move, and you can find yourself in a much more difficult place, as the case progresses. And I think, the other thing people ask is, how do we do this? And the place that we start is really with fundamental research and hypothesis generation. Where could the counterparty have the assets that aren't identifiable on the public record? Where might they move them in anticipation of the claim? And upon completion of that kind of open source gathering phase, we'll then engage our network of discrete, well-placed human sources, either adjacent to or directly associated with the debtor, be it a state actor or state-owned entity, and try and get some commentary that would help point us in the right direction, if not outright identify something immediately attachable. And the second way that we're often brought in is just gathering intelligence in support of the underlying case itself. We're here for arbitration, but it could be a civil lawsuit that might be funded by a litigation funder. And that might be helping counsel with fact gathering as part of preparing a brief, supporting with identifying information beyond just the discovery process, research they would like performed, potential lines of inquiry that they think could bear fruit to move the case forward. And that's likely why, a counsel might be considering outside funding as part of that mandate might include engaging an investigator to run down or develop new leads.
Great, yeah. And one of the interesting things about enforcement is you can think about it as there being kind of factual enforceability problems and legal, right? So factual, can you actually go get the money from these people? And then legal, which is one of what I think is one of the more interesting topics in this space, which is intra-EU bits and ACMEA. And maybe before we move on, if Kristen or Jeffrey or anyone else has some thoughts on that issue and how much those decisions have chilled the funding market in intra-EU disputes.
Sure, I could start. Absolutely, it has had what one might call a chilling effect on the funding of intra-EU bit matters, because there is such a large risk in terms of enforcement. As we all know, arbitral tribunals themselves have, with the exception of one case, granted them, consider that this does not prohibit them from exercising jurisdiction under the treaties. So they have issued an award. But then the question is enforcing those awards and whether you can do it in the EU, outside the EU. And of course, there are creative ways that people are working on that. But in terms of funding new matters today, I think it's very risky. And I think even as attorneys advising a new client that had an intra-EU bit, I mean, that would have to be part of the analysis in terms of actual recovery. So I do think it's very difficult, and funders have rightly so taken a look at this, and I think it's enforcement's too risky.
I mean, it's very difficult, quite frankly, because any investment opportunity that you're looking at, whether it's a treaty arbitration or a commercial arbitration, you're looking at, how much are you investing? How long will it take to collect? And when you have to do the modeling and look at your IRRs and ROICs for a case where you don't know what's going to happen. I mean, so I would make a couple of distinctions. So you've got claims versus awards. So, if we're talking about a pending claim on, under a intra-EU BIT, very difficult, if not impossible, to get funding for that. I think that's pretty clear. If you're talking about an intra-EU BIT award, potentially you could get that monetized at very distressed pricing. I wouldn't rule that out entirely. It's possible. A lot depends on the sovereign it's against. A lot depends on whether it's an exit or a non-exit case, quite frankly. And then if you leave the world of intra-EU BITs for a moment, the far more lucrative space is ECT awards. So if you have an ECT award, and again, you have an ECT award that is an exit award. So you're not subject to the vagaries of national court somewhere in Europe, but you have an exit ad hoc committee that's looking at this award. And the vast majority of exit ad hoc committees have dealt with awards in the PV sector quite responsibly. Those awards have been the subject of transactions for several years now. What's changed really is the pricing. So it started much higher in terms of the discount to the face value of the award. So several years ago, you could get 60% of the face value of the award. Today, it's considerably lower for these awards. And that reflects the fact that, some of these awards were acquired. They're now being enforced around the world. There's been favorable jurisdictions in both the favorable decisions from both the UK High Court and also Australia. And hopefully there'll be one here in DC first half of next year. So there have been favorable developments, but the pricing has gone down considerably, I think. Also, the market is different. There's the players that are buying awards versus the players that are funding claims are two different worlds, quite frankly. The folks that are buying the awards for the most part are hedge funds and multi-strat firms. So they look at these awards as just another distressed asset. And they would typically outsource their diligence. They would get a law firm to write an opinion, and then they would proceed on that basis. I think, and no one of these entities is buying just one award. They're buying multiple awards. I don't know of any fund that only buys one award against a certain sovereign. The idea is you would accumulate awards and then use those as leverage to effect a potential settlement. So I would say that's an option. But yeah, in terms of claims, very difficult to get funding. And I talked about intra-EU, but even a new ECT claim is quite difficult to get funding for these days, depending on the profile of the respondent. I haven't talked about the profile of the claimant, but that also matters now, because we're in a world where if you have an exit award, an ECT exit award against, a PV award against a certain European sovereign, but if you have a non-EU claimant, that's going to attract higher pricing because you're not dealing with the EU issue at enforcement. Again, you're not going to be enforcing anywhere in the EU. It's going to be outside of the EU, but the fact that you have a non-EU claimant will increase the amount that you're going to get. And most of these transactions are not complete upfront 100% payments. Most of them are participation agreement deals. So there's a certain amount upfront, and there's a certain back-end participation for that claimant. But yeah, I mean, it's difficult to argue with what you said. It's very difficult. The main space we're seeing transaction is in the award space, and I think that's probably going to stop at some point. Absent some favorable decisions in certain jurisdictions. So I'll stop there.
Great, yeah. And so we started talking a little bit now, just kind of more broadly about what types of cases are getting funded and what that funding diligence process looks like, what funders are looking for. And maybe, Lisa, we can start with you as someone who's kind of gone through the funding process as almost like a third party, right? As the expert advising funders or the client seeking funders. Can you tell us kind of what your experience has been? What does the funding process look like? And how has it maybe changed from your time following it?
So in fact, I have not been involved in a funding process. I've been historically, actually early on in the funding world, I was involved in cases where I didn't even know they had been funded. So experts were protected from understanding that there was funding. And I only found out after certain discovery was being requested in the process, which I think is not a great position to put an expert in. So now clients, which I consider clients, the corporation and the counsel that represents them, because I do mostly corporate work, are disclosing that earlier. But the way I think about it is, does the involvement of a funder impact how I or the expert I'm opposing is going about his or her work? And to date, for me, at least in my work, I have not had an experience where I've had limitations to the extent of work I need to do or the kinds of analyses I do. The panel earlier talked a lot about the various kinds of structures that a quantum expert can use in his or her work. So I've had no constraints in that regard.
Great. And Kristen, do you want to talk a little bit about what you're seeing in the funding market, and are there particular types of cases that are easier or harder to get funded? We've seen some consolidation in the funding
He's
space.
probably the expert on this subject. No, I think we've seen the industry become much more sophisticated over the course of the past, I don't know, dozen years. I think we all were talking about when we first started practicing arbitration, there was some third-party funding happening, but not to the extent as we know it is happening now. And I think in terms of case evaluations, most of your major funders, of course, they have very sophisticated experienced arbitration practitioners like Jeffrey Burford, who know how to analyze the cases, to assess not only the damages, to make sure that the quantum is workable with how the funding arrangement is, but also to look at jurisdictionally, what are the challenges, factually, what are the challenges. So there's really, the due diligence period is very deep and really scrutinizes what the claims are, how strong they are, what challenges there are, in addition to, of course, what the quantum is. And part of looking into the quantum is what Lisa was talking about in terms of getting a very early assessment from an expert to indicate what sort of range are we looking at for damages, and is this going to be workable? And then another part of figuring out that equation is then also considering, is insurance playing a role here? And if we need award insurance, we have to build that into how the funding arrangement will be structured. So all of this just means it's I think, a more time-consuming process, with the end result that the funder has a further assurance that it's a strong case. I think also, and Jeffrey can correct me, there's also some analysis of looking at who counsel are, what the track record is, and looking at that type of probability of success as well, in terms, not just the claim, but who's bringing it and what track record they have. I think that also plays a role in terms of getting a case funded. But what they're looking for certainly would be, really strong liability evidence, and of course quantum that is going to have enough to work with the way it's partitioned after the award is issued.
Yeah, no, I was just going to add to Kristen's point that, for corporate investigators and intelligence professionals, we're increasingly brought in by litigation funders to assess not just the quantitative component, but the qualitative component of the underlying case. We had a matter last year, we were approached by a litigation funder, assessing a claim against a state where a government administration had changed, and then, an asset was abrogated prior to an auction of a privatized state asset. And the funder wasn't yet interested in necessarily, attaching assets or, taking the claim forward, but they wanted to understand the fundamentals of it, the actual fundamentals of the case. What was the nature of this government's decision? Was there information to support the claimant's, central claim that the actions were done not through, legitimate legislative or administrative process, but specifically, in this allegation to punish our client. Additionally, as to Kristen's point, we're also brought in to do these deep dive due diligence backgrounds of counsel, expert witnesses, and just to, arm the litigation funders with as much information as they can have to assess, the qualitative nature of that claim.
Yeah, I mean, I think your first point, I've certainly seen in my own experience. Sometimes it can be very difficult when you're reading the memo about something that happened, right, years ago, often in a very different type of country and culture that, at least I normally live in, right? And you're like, hey, I really can use someone on the ground there to understand, to talk to people there, and understand, exactly what happened. Jeffrey, we can't close this topic without getting your thoughts on it. So tell us what you're seeing, what's getting funded, what's not, and one of the things we talked about was purchasing awards. Can you say a few words about what that looks like as well?
Sure, happy to. 3 points really. The first is the publicity of funding or award monetizations. A decade ago, you wouldn't see corporations announcing the fact that they're trying to monetize an award or that they secured funding for their claim. Now, you look at the first half of this year or this year up until now, dozens of announcements of claimants just securing funding, or in some cases, and this the first time I'd seen it, they didn't secure funding, they secured an intention of funding, and they issued a press release. And then the problem with that is they have to update the market. So they've secured, an indicative intention of funding, and then, so that may or may not progress to actual funding. But you see, in more concrete terms, you see Fortune 100, 500 companies engaging in these transactions with some regularity. You see companies telling their shareholders that they're looking, in this case, we had a couple of years ago, there was a company that had a oil and gas company that had $1 billion award against a particular sovereign. They told the market that they're looking at 3 things. They're looking at enforcing it, they're looking at settling it, they're looking at selling it or monetizing it with the nomenclature. And that's what they told the market. And that's what they did. It ended up settling, but those are the 3 things that they were doing. A couple months ago, another company with a large award, several $100 million, told the market that they were doing those 3 things. That they were going to enforce it, they were going to try to settle, or they were going to try to monetize. So we're seeing that with some regularity. Companies announcing it. You're also seeing it in the financial statements of companies, or on Pacer. I mean, if you get a Pacer account, you can see these awards, and then you can see the deeds of assignment in Delaware for awards against Venezuela, here in DC for awards against Spain, because the new owner of the award post-assignment is the one that will be appearing before the district court. So number 1 is publicity. Number 2 is really the success rate of funded cases. We're now at a point where there's been enough cases, there's enough disclosure, enough time has passed that you can see that, and there's been studies. There was one done by Debevoise a couple of years ago, that I think in that one, INA showed that at least 60% of these funded cases were successful. I mean, I think the rate's higher, but the bottom line is the idea that, and we did rebut this with UNCITRAL Working Group 3 in terms of data, but there's ample data out there to show that these funded cases are winning. Not a month goes by where you don't see another case that was funded, and you may have to look to the award to see the fact of funding, but there's been awards against Peru in the last month, awards against Tanzania in the last 2 months. I mean, this year there's been a number of awards that have been successful. So it's, these are good, these are solid claims. And then finally, I would say secondary market transactions. So folks are buying these awards, and then they may be selling participation interests in those awards. It doesn't have to be awards, it could be claims. I mean, I thought the last panel was very good, but what we didn't talk about was what could be the largest mining arbitration ever, which is the one that will be filed in the next couple of weeks against Panama. One of the largest mines in operation, 10 billion invested, 25 years of operation, is going to be closed this week after a decision of the Panamanian Supreme Court. And obviously it's within their sovereign power to do that, but that is, in terms of the cases that are getting funding, that is a case that would be, not that First Quantum Minerals needs the funding, but that is a case that would be attractive to a funder. It would be attractive to monetize. I think folks would be interested in purchasing that claim from First Quantum. I'll stop there.
And Celeste, I want to get your thoughts on this. And one way to think about this is litigation funding. Another way to think about it is litigation risk transfer, right? And funding is one way to do that. Insurance is another. And so maybe to have you kind of look into the future a little bit and tell us how you see insurance fitting into this puzzle going forward. Do you anticipate the uses of insurance in the international space really expanding significantly the way it has in the past 2-3 years here in the US? What are you seeing?
Well, I mean, I think we certainly hope that it'll continue to expand, especially in the investor state treaty world. That's why we're marketing and increasing awareness about this product. But it's really hard to give a prediction on that in particular. I mean, we're certainly seeing that more and more hedge funds in particular, to Jeffrey's point earlier, they're not only buying these awards, but they're also seeking insurance. So the more that people learn about the processes and what's out there in terms of potential assets to acquire, I think they will look to insurance to protect their assets.
Yeah. And is it what are the factors that the insurers would be looking towards? Is it the identity of the state, respondent, the identity of the claimant, the underlying facts? Can you just give people a little bit of a feel for what that inquiry will look like? Is it similar to the funding process?
I think in some ways it is similar to the funding process. It's certainly a matter of the facts, the underlying facts, and the respondent party. So these are the two arbitration award insurance products that I referenced earlier are technically political risk products. So it very much matters who the respondent is on the other side of that V, whether or not they have a history of defaulting, because that's going to put them out of appetite, or whether or not, this is just a one-off scenario.
I have one more question that I want to direct to Sam and Lisa, and then we have a question in the chat, and then we'll take some other questions as well. And then we have a lightning round if we have time for at the end. Technology and the use of technology, right? Artificial intelligence is, expanding at rates that I don't think anyone would have thought about 14 months ago. Sam, tell us about what you're seeing in terms of the use of technology. How is it affected? How is it affecting what you are doing on a day-to-day basis? And how might it help cases get funded and get insured?
Well, maybe this is kind of counterintuitive, but I think what we're seeing is really a mismatch between expectations and reality when it comes to technology. I think a lot of people, and we observed that throughout the week, have been bringing up AI quite regularly. The expectation being there's a ton of information out there. There's a ton of intelligence information gathering tools that can vacuum up and analyze all this information. And therefore, it's very simple to just piece together. And the expectation that can be done so instantly or quickly. And I think it's been a challenge to deal with for professionals in this field, because conducting that work does require time, analysis, consideration, putting the pieces together, interviewing relevant witnesses to track down assets, and this can be time consuming. And when I say this, I mean to have it done properly and without error. I mean, I think leveraging some of these tools can be a time saver, but you need to be spending the time necessary to review the output that it's providing you. So I think there are, of course, those promising speed along with results, but they fall short on the former. But there are new tools, as you say, and all kinds of new deep and dark web search tools and web scraping tools and tools that pull together social media and other open sources, and you can identify relevant connections, and you can quickly try and identify corporate registry information. And we've talked about earlier, as we heard at Allen & Overy on Monday, these tools, I think Kelby presented these, that are able to speed up the discovery process and like that, and they ought to be leveraged as much as possible. But I would refer to them as time savers and not yet replacers. So in regard to AI, I think this is something that everybody's assessing. We're certainly assessing it as a firm. We're doing so very, very cautiously about what we can put into it and what we can't. So it's not something I would say we're actively using, on every engagement yet, except in very, very specific cases, and also in close consultation with counsel as to what information can be put into it.
So what are you seeing on this?
I fully agree from the extent to what I'm seeing with Sam. I think these are tools to assist and accompany the work that we do. Valuations, when you're doing financial statement valuations, to a certain extent, that can become a repetitive tool, and you can use the existing tools, everything from Excel to other data analytics for the purposes of what are repeated valuation analyses. I think in our space, in damage quantifications and in valuations, I think what we're doing is so nuanced. I don't see that becoming a tool that can help us. Where I do see it helping is in the analysis of very large data sets, both through the kind of AI that Sam was just talking about, and in the ability to code more efficiently. And so I think that will start to have an impact on that piece.
Anyone else want to weigh in on technology before we move on?
Just a word. I mean, I
Yeah,
think
please.
it's much easier, I think, for AI to have a more significant impact in US federal court litigation, for instance, where they have access to PACER. International arbitration, you just don't have that. So there is no PACER for ICC arbitration. So those awards are not available. There's a paucity of information that you can get about that. You can now get the identity of arbitrators, but you don't get the actual case name. You get a case ID. So there just isn't the data to apply AI in commercial arbitrations. On treaty arbitrations, the data is there, but a lot of it is behind paid platforms, or it's just not been used in the tools that are available. So if you run a search for an arbitrator on some of the tools that are available now, and I've done that, you don't get anything that's useful. Whereas you go to Use Monday and you do it because they know what they're doing, you get a useful result. So we're just not there on the treaty side. But I think they are making some significant gains on litigation where they have access to all the data, for instance, in district courts in the US and increasingly state courts as well. It's just arbitration will just never be that way because there's no one repository for all that information.
I would just say, I feel like we might get there in treaty arbitration someday, right? I mean, when we started practicing, we had nothing. There was no Westlaw, there was no Lexis. We, as a first year associate, I would print off, of course, the pace at which awards came out was a little bit slower, print off, flag, highlight, and just had a stack, right? And then very quickly after I started here at White & Case, we then had available databases that you could search, and now of course we have lots of different options. So we could get there, at least on the treaty side, because there is more transparency and disclosure. It's not perfect, not everything is disclosed, but if there's a fair amount out there. And now, of course, you have procedural orders also going to be published. So you will have a fairly large repository of decisions in that particular space. I think Use Mundi is also doing some sort of beta testing of something. I haven't looked at it yet, but so I do think it would come a lot faster than other areas.
Any thoughts on this? We have one interesting question in the chat, which I don't know the answer to this. There was a question about the UK PACAR decision, PACCAR, and whether that's going to affect international arbitration at all.
You're looking at me, so
I'm looking down the mic.
Does anyone else?
I don't have any.
It's a really interesting decision. I'll just say a few words. First of all, it doesn't involve our international arbitration as a starting point. So that's our point number one. Point number two is there are already moves afoot to have a legislative solution in the UK for what this has resulted in. So, watch this space. I think it was an unfortunate decision, but I think there'll be a remedy in due course. It's not going to be quick. I think it's a slow process, and it's not going to be, it's not going to, the moves that have been taken are just in respect of CAT proceedings so far. So it'll take some time, but, technically speaking, currently, it doesn't apply to international arbitrations. That said, when we look at risk, if you're looking at, having a seat in London, or if you're looking at, should we use UK law or New York law for this funding agreement? This is a factor amongst others that weighs in favor of, say, New York law until this is resolved. But I think it's unfortunate, particularly because London has been a leading jurisdiction for funding, generally speaking. So it wasn't expected. I know a number of folks have said that it was expected. I don't think folks really expected it. But it's by no means a death knell at all. It's just unfortunate. And I think there'll be a solution in due course.
So I just want to add, because I think it's relevant to what you said about Panama. I'm glad you pointed it out. Actually, the Supreme Court ruled on Tuesday about the decision on the second instance that it was brought up, unconstitutional. That will be coming up.
No, I aware that I agree. I think there was the decision came out this week. Once it's published in the official Gazette, they're going to proceed to close the mine. And obviously, it is well within Panama's right to do that. It's within their sovereign prerogative. It doesn't mean, though, that they don't need to pay compensation, prompt, adequate, and effective compensation in light of the expropriation that they're in the process of effectuating. So it may take 4 years, but it's going to come.
This question, I guess, is mostly for Celeste, but you mentioned these two arbitration insurance products. Who is buying it? How much does it cost? Are people using it in order to obtain funding, sort of in the same way that you would go to an asset tracer to help increase the likelihood that you would get funding for a case? Or is it really just people like the hedge funds who are buying up awards? Like, and really, how much does this cost?
Okay, so I'll try to be clear. So there are two different products. One is effective at the arbitration stage. That's when you start procuring it. And that is more so being acquired by claimants in the proceedings, or sometimes the lit funders themselves. If we're talking about the enforcement stage product, oftentimes we will work with counsel and have them maybe negotiate their budgets with their lit funders so that the cost of it is covered. And it's, again, going to be the claimant that's usually acquiring the insurance at that stage. In terms of cost, going back to the first product, the one that you procure during the arbitration stage, that's going to range from 6 to 13% of the limit. And that's a product of sort of the political risk ratings that the insurers have on different countries. If we're talking about the enforcement stage product, that is a lot more expensive. The rub there is that even though it's a lot more expensive, the premium can be paid, or a portion of it can be paid at binding. And then at year 2 or 3, they sort of reevaluate whether or not it's even necessary to pay the remainder of it. And that's going to be based on whether or not, you were able to recover anything, the asset tracers were able to find assets that sort of satisfy that award or anything like that. So it varies.
And I think that's an interesting point about how funding and insurance can work together, right? Because with insurance, you're paying a premium, right? You're not getting money, you're paying money. And so you need to get that money from somewhere. And that's where the two can really work together. Any other questions?
Question for law firms. Yeah, might not be fair because, but on AI, one of the limitations is of course that some of the information on various investor state arbitration proceedings and you want to walk into the space of international commercial arbitration more is held by major law firm players, and there could be prospective projects of AI ventures to try to get all that information and sort of looking to creating perhaps an inside protected intranet or AI intranet to be able to model cases. So that is highly complex, but there are projects of this sort. So I wonder what comments you might have. Third question, because it doesn't only involve one firm, but it also may involve many others.
For use by the firm, or I would assume it would have to be by use for the firm in terms of confidentiality. Right. I mean, look, I think in order for a law firm to use an AI product in any event, it would have to be limited to firm use, because you have, of course, confidential information that could not be disseminated on a public database. So I think for any lawyer using these products, it would have to be something that's contained within a law firm. Now, whether a law firm could create a more sophisticated AI model because they have a repository of additional confidential awards, I mean, So long as it's within the framework of a law firm, of course, you wouldn't be violating confidentiality, depending, of course, on the language of the confidentiality agreement. I mean, it could be done. I don't know. Certainly, I'm not aware of anyone undertaking that task right now. But certainly, I think all firms across the world are looking at how to use AI to make cases run more efficiently or cost effectively. That's, of course, something to be done, but we cannot, of course, input confidential information into a public database.
2 minutes left, so we'll do one lightning round, 20 seconds each person. What advice do you have for lawyers seeking funding for their cases? Or insurance, thank you. Seeking risk transfer. Can't take up the whole time waiting. So I'll start calling on people.
Do you have a thought on it?
I would say put your best foot forward from the start. I think too many people send just a bunch of scattered materials and say, hey, can you get funding? If you put together a thoughtful, cogent memo, your likelihood of getting your case funded goes up by 10x. That would be my advice.
And I think appending an initial, very preliminary damage assessment to your memo is helpful.
Yeah.
And we've also done then meetings with funders to walk through what we believe to be the strongest pieces of evidence underlying both jurisdictional liability and damages as well. But putting all that together, I think it can make your case much more persuasive and perhaps more likely to be funded.
Sam?
I'm gonna agree with you on that one. I'm not seeing the cases as much, from a funder's perspective, as much as from an investigator's side.
Based on what both you and Kristen said and other conversations I've been having recently, it seems to me that working with counsel who has experience with funders previously can make a difference in terms of your ability to get funding. It's just like any case in white collar, right? It's all about the relationship of the attorney with the regulator. In this instance, it's about whether the lawyers have an existing relationship with funders and understand that world.
I would just reiterate what you said, Will. I think it's very much true for insurance underwriters that they see like a very well put together submission in order to make that risk assessment.
Jeffrey, you want to close this out?
Pick the right counsel. Susan Frank's research shows that it makes a difference for claimants as well as for respondents in terms of the amount of damages that are actually owed. We do look at the win-loss rate for firms, and we do look at the win-loss rate for offices of firms. So some offices of White and Case have a better win rate than other offices. These are facts that we use. And importantly, those firms that have experience funding know how to prepare the documents for the funders, and they know what we're interested in. There is a correlation between the cases that we see from GAR 10, GAR 30 type firms and firms outside that. So I would say that.
One thing I think we talked about when we were preparing along that lines was the tension of that and also the desire for the arbitration world to become more diversified along gender and race and a lot of other measures, right? And so if you're always going to the people that have been recognized and have done the work before you, probably more often going to a white male. And so you really do also have to think about that.
Well, and that's why there are other initiatives that want. So for instance, we have this thing several years ago, we introduced it called the Equity Project, whereby we committed $100 million to fund cases led by women, for instance. And that's something that fund is now closed, and we're moving on to other. So there are other things that one can do to ameliorate that situation.
Thank you.
Yeah.
It's been wonderful. Thank you so much for your time. Thank you to the audience and to Jose Antonio and his team. So, thanks.
Pardon?
Susan Frank was my professor.
I'm a big fan.